Hello, everybody, and welcome to Law Bite number 303, dated August the 24th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This Law Bite is entitled Foreign Law in American Courts. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. In addition to that, please also click on the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and informative videos in history, law, political science, theology, and philosophy. Thank you in advance. Again, this video is entitled Foreign Law in American Courts, and it actually was my last term paper as a graduate student at the University of Baltimore. All right, the course was Law and Morality in the spring 2018 semester, and it was taught by the very distinguished professor, Dr. James Taggart. Okay, so let's get to it. So it begins in explaining what foreign law is. All right, foreign law simply consists of the laws governing provisions, judicial decisions, and resolutions of nations outside of the United States, or more generally speaking, the international community. Every single nation in the world, as you would expect, has laws which govern their societies. And of course, these nations range from very democratic to outright totalitarian. As time progresses forward and the world grows smaller, the nations of the world, as we know, are becoming more and more interconnected in various ways. This includes technologically, economically, militarily, politically, and of course, legally. With that, the ancient barriers which traditionally kept countries distant from one another and even isolated no longer remain. Many nations today have more of a collective, global, and or regional focus rather than a singular national focus, or emphasized by nationalism, okay? Examples of this are clearly displayed with institutions such as the United Nations, whose flag is represented right here, okay? As well as the North Atlantic Treaty Organization, otherwise known as NATO, the World Trade Organization, the WTO, the North American Free Trade Agreement, NAFTA, the Organization for African Unity, the OAU, and of course, the European Union, the EU. So as the international community grows closer, legal systems, as you would expect, often find themselves directly or indirectly using that of others, all right, for the as resources for the development of their own legal systems. All right, we're one big world, ladies and gentlemen, for better or for worse. The United States of America, of course, is no different, as it has both imported the laws of other nations and exported our own theories of justice elsewhere. That should come as a surprise to no one. Not everyone, however, believes that the courts of the United States should be inclined to reference the laws of other nations when making judicial determinations that affect the American people. Legislative enactments are, of course, one thing, all right, as they can easily be repealed or outright amended, okay? But judicial holdings are not so easy to circumvent or modify should defects be discovered. Additionally, American judges take oaths to uphold and defend the laws of the United States, not other countries. This will expound upon the arguments for and against the usage of foreign law in American courts, as well as explain my position on this very contentious subject. So we begin with the arguments for the use of foreign law, okay? So there are many arguments made by American jurists and scholars which defend the use of international law by the courts of the United States, okay? Specifically, its use is very adamantly defended in the tribunal where it is most likely to be of use, the Supreme Court of the United States. As the highest court in the nation, the Supreme Court, of course, makes constitutional and statutory determinations which affect the entire country. Interpretation requires sources, which brings us to the first argument in favor. The first argument contends that judges already use other scholarly sources to defend their decisions. These include law review articles, legal journals, the Federalist Papers, and more. With that in mind, foreign law is no less scholarly than the aforesaid sources, and perhaps it is indeed more authoritative as an influence per se, as a persuasive authority, certainly not a binding authority. They contend that the decisions of foreign courts, while scholarly and persuasive in their holdings, like I said, are not at all binding precedents, all right? Thus, American courts are not obligated to follow them, and thus, need not be referenced unless whatever tribunal happens to be interpreting them chooses to do so as nothing more than a persuasive authority. It is totally up to them whether or not to use foreign law. All right? It is not binding upon our courts. This is true, essentially, even with respect to the extra constitutional sources that the Supreme Court justices often utilize to justify their decisions. These sources are not officially law, okay, but merely persuasive authorities, and thus having no more effect other than what our own Constitution would permit. As nations exist overseas with similar values, cultures, and systems, it makes no sense why American courts could not reference the judgments of courts in those places with the ease of native sources. Additionally, as other nations often reference American law, reciprocity is very important in building international cooperation. A non-binding source should never be perceived as a threat to native sources, so to speak. So the next argument in favor of using foreign law is that an increasingly large number of cases mandate that judges know something about what occurs in nations outside of the United States. It is estimated that some 15 to 20% of the cases federal judges hear in modern times have at least semi-international issues in play, okay, such as national security, privacy, the environment, copyright, commerce treaties, and much more. As such, the judges adjudicating these issues will need to be at least somewhat familiar with law, facts, and decisions from other places to be able to make the best decisions on these complex legal issues. To not have these sources available would not be an asset, okay? But by contrast, it would be a severe detriment to justice in the long run. The third argument in favor of foreign law is that the United States cannot exist in a bubble from the international community. We exist in an ever-changing world which is growing smaller due to technological advancements every day, as I mentioned above. As societies evolve, the United States must keep abreast of these changes and not fall behind the rest of the planet in terms of human rights, civil rights, and freedoms in general. As American courts interpret our laws and are bound to them, they should keep abreast of what's going on around the globe and its potential effects, thus to remain in tune with the times. It's really not that difficult, okay? To not do so would place us behind the rest of the world in many areas, although we don't seem to mind that from time to time, all right? But in doing so, it would lead to a negative international perception. Again, something the U.S. doesn't seem to mind, however, from time to time. The fourth and final area of defense when it comes to using foreign law is its potential aiding in the development of domestic policy in the United States. When judges make constitutional decisions, especially at the U.S. Supreme Court level, they are resolving a case or controversy involving some sort of policy affecting the American people. That goes without saying. All right. Quite often, it can be difficult to resonate these policy problems with the Constitution, and it may help to reference the laws and policies of nations with similar issues as our own. Okay? As stated before, the practices and policies of other nations are not binding in any way upon American courts, ladies and gentlemen. But they can certainly provide useful guidance with respect to how we may be able to handle these similar or darn near parallel issues at home. An example was made by U.S. Supreme Court Justice Stephen Breyer on how useful it was to research foreign law in a case involving state-funded vouchers at parochial schools, and how several European countries managed to do this without sectarian strife as a result. The conclusion for this is that American courts may well suggest this to policymakers within their opinion as a means of reforming our own policies in those areas. We are not perfect, and throughout history have often borrowed the examples of others in our policy choices. Okay? Now that takes us to the arguments against the use of foreign law in American courts. With the many strong arguments for the use of foreign law in various circumstances, there are also many very powerful arguments against its use in American courts. The first argument against the use of foreign law is the fact that the judges on all court levels in the United States take an oath and affirmation to uphold the United States Constitution, not the laws of other nations. These individuals contend that judges have a duty to interpret the laws of the United States of America alone when performance of their duties. The usage of law review articles and other extrajudicial resources is absolutely fine if the source is one based upon American law or history, which has influenced American law per se. For a sworn American judge to look beyond the borders of the USA, outside, of course, of the British common law from which our law draws its roots, for guidance on issues directly affecting the American public to these individuals is simply unacceptable and never justified. Okay, in other words, outside of the British common law, all right, or law or sources that have directly influenced American law or history, it is unacceptable to pick law from sources that have played no role in the development of American law, all right, when making judicial decisions, all right? So it is emphasized that our law has been the primary source of guidance for well over 200 years and should remain so. The second argument against the use of foreign law is that Americans should be governed by American law and precedents always, not the influence of foreign countries. While the world is growing smaller and borders are slowly disappearing, the American people are a unique society with no parallel, no complete match in the world. Those making this argument will often contend that our people have special needs that only American law can resolve. After all, no other people are Americans and can fully replicate our culture. They might come pretty close, but it's no cigar. The law is not a one-size-fits-all thing, and it is simply illogical and unwarranted to impose the laws of other people on the American public, no matter how parallel the society in question purports to be. The third argument is that the use of foreign law is nothing more than an empowerment tool for judges to look beyond the Constitution and valid precedents and impose their own viewpoints on the American people, disguised as law. All right? In the interpretational process, judges are properly supposed to reference the Constitution, case precedents, and other relevant American legal and historical influences when making decisions. This confines them in their interpretational abilities, and at least in theory, restricts how far they may go when reaching conclusions. Allowing judges to use foreign law serves only to lessen contextual constraints against judges, further permitting some of them to use that source to impose personal viewpoints and policies upon the American people, for better or for worse. Judges are not supposed to be the experimenters in a giant lab of policy, okay? As aides, they are only to follow the direction of the scientists in the lab, all right? Judges are not the scientists. That's the job of the legislative branch, to be the experimenters. The judges are merely the aides carrying out the directives of the scientists. You get the point, all right? That brings us to the last argument against the practice, which is the arbitrary and subjective use of foreign law to defend conclusions, very specific conclusions that are sought after. When it comes to the Supreme Court of the United States in particular, the use of foreign law is highly subjective and very cherry-picked, so to speak, to suit various conclusions. That should not be. Indeed, it weakens the case for using it when those sources are only referenced when the court wishes to reach a certain type of conclusion and never any other time. This is most notably seen from the court's liberal-leaning justices, I'll add. The late Justice Antonin Scalia noted this type of hypocrisy from the left wing, pointing out, in his very candid manner that he was known for, that the left tended to only cite the laws of other nations in certain types of constitutional cases. Those would typically be about gay rights and capital punishment, all right, where other countries' laws tended to be more liberal than the U.S. In other areas such as gun control, all right, criminal procedure, and abortion, all right, these areas, international law was hardly ever used. Why? Because other nations' laws tended to be far stricter than American laws, all right? Even though with the question of gun control, you would think that the left-wing justices would be all too happy to reference foreign law, because most nations around the world have substantially stricter gun control laws than the U.S. All right? So foreign law tends to only be referenced typically by the left when it is indeed used to advance a particular cause. Rarely and logically, of course, is it ever used in other areas, all right, which would certainly work against their arguments, okay? So this further adds to the illegitimacy of foreign law being used in American courts due to the fact that it is indeed referenced very selectively, and, in a very inconsistent manner. So if certain jurists insist upon using foreign law, at least be consistent with it, not only when it is convenient and to advance certain policy agendas that arguably are better handled by the legislative branch of government, all right? Both legislative branch on the federal level and within the states, all right? So that takes us to my position. So with compelling arguments on both sides, and you have to admit some of those arguments, very good on both sides of the coin, my personal position on the subject is to view foreign law as a valuable resource to be used as a supplement to existing U.S. law and as a reference when necessary on cases where such knowledge may be necessary, all right? But in my opinion, it should never be the solid basis for a legal rationale for any U.S. court. The evidence has been shown where knowledge of foreign law is indeed essential in some circumstances to making proper judicial determinations in many areas, especially where technology and trade are concerned. Because of that, it serves a very vital purpose when it is needed, okay? Aside from this, however, American courts should always reference U.S. law as the primary basis for their decision. And foreign law, be it, court decisions, statutes, or other types of enactments, it should always be secondary, all right? To have it as the foundation of any U.S. court decision undermines the legitimacy of that decision, all right? Because judges in the United States are officially bound to the laws of the United States alone, okay? Everything else to the contrary, notwithstanding, okay? So in conclusion, the debates over the use of foreign law, all right, in American courts both present a multitude of well-reasoned, principled arguments to support their cause. And at the end of it all, both sides can claim victory, all right? Despite this, the facts tend to stand more toward the advocates of using foreign law, all right? Because the U.S. Constitution prescribes only that it is the preeminent law of the nation, not the only source of law which can be used to make constitutional decisions, it is technically not out of the question to reference foreign law at times, all right? It is not barred by the Constitution, in other words. With that said, if American courts never directly contravene the Constitution when they use foreign law, but merely use it as a supplement to our law, the justices have committed no legal error in their process of interpretation. All right? A more perfect union is what we're striving for every day. So that concludes my video on the use of foreign law in American courts. I know a lot of that might have sounded, technical and confusing if you're not familiar with the subject and hearing legalese and, the use of a lot of extrajudicial terminology. But as with all things in my videos, if you have any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video, learned something, gained something from it, please drop me a like. It means more than you will ever realize. Just a simple like. And if you've not done so at this point, I invite you to subscribe to my channel, Juarez Lee Shelton, MA, before you leave. If you made it this far, I truly appreciate you listening to this whole video and sincerely hope that you enjoyed it. Thank you so much. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.